If you've been following the Second Amendment and the Supreme Court over the last decade or so, you probably have noticed that it's been really kind of a long time since the Supreme Court has issued a major decision on your Second Amendment rights. Arguably, it's been over a decade since they've done anything huge on the Second Amendment. Have you asked yourself, why has it taken so long for the Supreme Court to decide another huge, major Second Amendment case? Well, we're going to give you a little bit of an insider's guide as to what I think is really going on at the Supreme Court in connection with the Second Amendment in just a moment when we come back. Hey folks, I'm Mark and welcome to the Four Boxes Diner. In 2008, the Supreme Court issued its landmark decision in the Heller case, the District of Columbia versus Heller. It was the first substantive decision concerning the Second Amendment really in U.S. history. So think about that for a minute. Naturally, a lot of folks in the gun rights community were very excited that the Supreme Court took that Heller case, and were very excited that the gun rights community won. And many people in the gun rights community thought this was just the beginning, that the Supreme Court would take more and more Second Amendment cases and they'd go on to invalidate all sorts of illegal gun control laws, which in my view are still out there with us. But of course, the Supreme Court didn't do this, right? These laws are still out there, and it hasn't happened that they've been knocked down. In fact, it's been over a decade, arguably, since the Supreme Court took its last major Second Amendment case. And why is this? Well, I want to give you a simple answer because I think it really is the right answer. And that is, it comes down to personnel. Personnel at the United States Supreme Court. Yes, that's right. It's really a personnel issue, or as they often say in Washington, D.C., personnel is policy. To begin, let's just talk briefly about how the Supreme Court decides which cases that they're going to hear on the merits. Again, there are thousands of cases that seek to be heard by the Supreme Court every year, and the court only takes somewhere between 80 and 100 cases depending on the term. So there's not a lot of cases that they hear, and there's a whole lot more cases that they refuse to hear, even though the parties would like them to take it up. Again, let's do a little bit of math here. Not heavy-duty math, not calculus, just basic math. You see, there are 9 Supreme Court justices. That's the number 9. And it takes 4 justices, I repeat, it takes 4 justices of the 9 to decide and vote to take a case and to hear a case. That's called granting certiorari ori, okay? Of course, it takes 5 justices to rule in a party's favor in order to win the case on the merits once the court has taken and heard the case. It takes 5 justices or more to win the case for one side or the other. Now, the 5 conservatives, so-called conservatives, found in the Heller case that there was an individual right to keep and bear arms, and this was decided in a 5-4 ruling, a 5-4 ruling in Heller in 2008. Bear in mind that while the so-called conservatives were in the majority, the 4 liberal justices basically concluded in the Heller case in their dissent that the Second Amendment doesn't protect any individual right of yours, and it doesn't protect any individual right of mine, whether to own guns or to carry guns or anything at all. That's how the liberals interpret the Second Amendment, as literally being an ink blot on a piece of parchment. Now, of course, this is all despite the clear text, in my opinion, of the Second Amendment. But why let the text get in the way if you're a liberal? Okay, now stepping back again. The 5 justices, and this is important, the 5 justices that voted for Heller and concluded we have a right to have a loaded gun unlocked in the home, those 5 justices were Chief Justice John Roberts, Justice Kennedy, Justice Scalia, Justice Clarence Thomas, and Justice Sam Alito. These 5 so-called conservative justices were on the Supreme Court together for another 8 years after Heller. But during that time, they never agreed to take another major Second Amendment case. Now, we will never know exactly why, because the court doesn't explain its reasoning when they decline to hear a case. But my guess, as sort of an observer of the Supreme Court and of the passing moment of history, I'm guessing what was really going on here is that the conservatives on the Supreme Court were worried that one of those 5 justices that ruled in favor of gun rights in the Heller case was not sufficiently solid on, the Second Amendment and gun rights, right? And I think that the last thing that the conservatives on the Supreme Court wanted to do was to roll the dice and take a chance by taking on another case and then find out that they did not have the 5 votes for a solid Second Amendment decision. And of course, I'm guessing on the other side, the liberals, sort of the anti-gunners of the group on the Supreme Court, must not have been convinced that they were going to win, so they didn't vote to take a case involving the Second Amendment either. And so in that time, you mostly had a stalemate between the conservatives and the liberals when it came to the Second Amendment during that time period. So then what happened next? Well, I want to move this story from 2008, where we had the Heller case, and 2010, where we had the McDonald case, which was really just extending Heller against the states and the cities, that you're allowed to have a loaded gun in the home, unlocked for self-defense. In the home, though, okay? Now, what happened next, I want to move the story to the year 2016. That's the presidential election year of November, where President Trump wins the election. But many, many months before that date in 2016, we all remember that Justice Scalia, the author of the Heller decision, passed away. And bear in mind, there was a fight about what would happen and who would replace Justice Scalia then. If Justice Scalia had been replaced on the Supreme Court by an appointee of President Barack Obama, that would have been, in my view, a disaster for Second Amendment rights in America. And if you don't believe me, just review the record for a moment. Go back to the tape. I think it's more than fair to say that President Obama did not like guns and did not like gun owners. Ample evidence of this, but just some of the proof that's in the pudding, as they say, would be, first, he nominated to the United States Supreme Court 2 rabidly anti-Second Amendment judges in the form of Justice Sonia Sotomayor and Justice Elena Kagan. They're both lost causes on the Second Amendment. They don't think there's any rights to bear arms in the United States, as best I can tell. So yeah, they would be, another justice like them would be terrible for the Second Amendment community. But beyond this, we all remember that Barack Obama's famous derogatory comment about ordinary Americans. Let me jog your memory. When he referred to working class Americans by stating that, hey, this is a quote, they get bitter, they cling to their guns and religion, or sometimes their anti-immigrant sentiment or their anti-trade sentiment as some sort of a way to explain their frustrations. So basically he said that we in the gun community cling to our guns, apparently. Well, that's what President Obama said, okay? And you also don't want to forget, and last but not least, that it was President Obama who nominated, ready? Merrick Garland. That's Merrick Garland to the Supreme Court, claiming he was some sort of a moderate. Now, side note, this is the same Merrick Garland who's now the Joe Biden Attorney General, doing all sorts of things, which you can read the news about. I'm sure you have. We don't need to go over that record, but I'm not sure Merrick Garland was the moderate that President Obama claimed he was. Okay, so again, we're going to go back to 2016. We had Justice Scalia passed away. And fortunately, and this is hugely important and hugely good news for the Second Amendment community, we had Senate Majority Leader Mitch McConnell in the United States Senate when the Senate was controlled by Republicans. He was the Senate Majority Leader. And Mitch McConnell made sure that there wasn't a vote on Barack Obama's pick for the Supreme Court. And he did so on legitimate legal grounds, saying that you had the president that was a Democrat, you had the Senate that was a Republican, you had a split government, and he was going to let the Americans break that tie in November 2016. And they certainly did with the election of President Donald Trump. Okay, so after Donald Trump becomes the president, he nominates Neil Gorsuch, who becomes the next Supreme Court justice, and he fills the seat of Justice Scalia. Now, you should be happy to hear, in my opinion, I think there's every indication that Justice Gorsuch will be a strong supporter of the Second Amendment in the vein of Justice Scalia. So when it comes to Gorsuch, I think that's good news for the Second Amendment community, but we'll find out soon enough. All right, let's fast forward to the year 2018. Now, in 2018, Justice Anthony Kennedy retired from the Supreme Court, and he was ultimately replaced after a bitter confirmation fight by now Justice Brett Kavanaugh. I mean, how can you forget that process, right? The left absolutely hated the notion that Judge Kavanaugh would become Justice Kavanaugh, and they desperately tried to keep him off the Supreme Court, but of course they failed. Now, many folks in the pro-Second Amendment camp thought that one once Brett Kavanaugh, or Justice Kavanaugh, was confirmed in the Supreme Court, we would again start to see more Second Amendment cases being decided by the court, because bear in mind, going back, a lot of people thought that it was Justice Kennedy who Brett Kavanaugh replaced. It was Justice Kennedy who was the longtime swing vote of the court. That fifth vote that whichever way he voted, either the conservatives would win the hot issue or the liberals would win the hot issue. He was kind of, again, Kennedy was the deciding or the swing vote on the Supreme Court for many, many years and in many, many cases, including, by the way, in 2008 when Heller was decided. Time and again, Justice Kennedy had proven to be an unreliable, fair-weather friend to the text of the Constitution and to the original understanding of the Constitution at the time of our founding. For example, on gay rights questions, it was Justice Kennedy who sided with modern liberals, finding that the United States Constitution somehow did indeed protect the right to gay marriage, even though there doesn't appear to be any reference to gay marriage in the U.S. Constitution. And same again for certain abortion cases. Again, abortion is not referenced in the Constitution, unlike, of course, the Second Amendment, which is the right to keep and bear arms, is actually mentioned in the Constitution. So, and when it comes back to Kennedy, there was good cause to be very worried, if you're conservative, about whether Justice Kennedy was solidly in the pro-Second Amendment camp, and whether or not he would rule to extend Second Amendment rights the way he should under the text of the Constitution. So when Justice Kennedy was ultimately replaced by Justice Kavanaugh, who again, before he was nominated to the bench, then Judge, now Justice Kavanaugh, had issued some very strong pro-Second Amendment opinions, one in particular in a case called Heller 2. Many conservatives thought that Justice Kavanaugh would start causing there to be more cases challenging gun laws and restrictions being heard by the Supreme Court. Okay, so let's continue our story on the timeline. So now we find ourselves in the late fall of 2018. We now have Justice Gorsuch on the Supreme Court along with Justice Kavanaugh after that bruising confirmation fight. So if you're a conservative, you're feeling pretty good. You expect the court to start taking some Second Amendment cases and striking down anti-gun rules and regulations that clearly violate the text of the Second Amendment. Well, again, this didn't happen either, right? Now, as to why this happened, some sort of speculate, and I think it's a fair assumption, that all of a sudden the new swing vote on the Second Amendment became Chief Justice John Roberts, really, who became kind of the weak link, right? Roberts was, as best I could tell, was very concerned about the appearance of the court, almost more so than following the rule of law. But who knows exactly what Justice Roberts is thinking. The bottom line is, it appears as if he may have been the weak link on Second Amendment cases. I guess we'll never know. But that appears to be the case for many outside observers, including myself. And again, you have to remember, it's at the end of the day a numbers game at the Supreme Court. A justice, whether they're a conservative, a liberal, it doesn't matter. They're not going to vote to hear a case. That, again, is called granting certiorari ori. They're not going to hear a case or vote to hear a case if he or she cannot win the 5 votes they need to prevail on that case, or to have the case come out the way they see appropriate under American jurisprudence. They would rather not take that case, because if you vote to hear a case and you don't have the 5 votes needed to win the case, well, you're really just giving the other team an opportunity to make more bad law against your view of jurisprudence, or you're allowing them to confirm the existence of a bad law that is being challenged. Either way, it's not a desirable result to hear a case and then find out that your view of the law does not prevail. That's not smart. Anyway, with Chief Justice John Roberts, my other speculation is that the other conservative justices were probably nervous, or too nervous to trust that they could count on Justice Roberts' vote to take a case, because they just simply could not count on Justice Roberts voting with them on a Second Amendment case in the right way. And again, without Chief Justice John Roberts, there was no 5 votes in favor of the Second Amendment. And again, remember, it was Justice Roberts who sided with the liberal justices in the Obamacare case, upholding Obamacare in 2012. He sided with the liberals and on that case and others. So I could see why it's common sense that you would not want to place the future of Second Amendment rights in America in the hands of some sort of fair-weather jurist who's got his finger up worrying about the prevailing winds of politics, rather than faithfully applying the text of the United States Constitution. I would say you wouldn't want somebody unreliable in that respect, that's going to perhaps allow other considerations to play a role in deciding how to interpret the clear text of the Second Amendment. Okay, so let's move forward on our timeline to the year 2020. And you may remember then that in the middle of the presidential campaign of 2020, Supreme Court Justice Ruth Bader Ginsburg passed away. You had a confirmation and nomination and confirmation of Justice Amy Coney Barrett to the Supreme Court. And this was a game changer, folks, a game changer for the Second Amendment community as I see it. Because getting Amy Coney Barrett on the Supreme Court was huge, because all of a sudden, even if one of the other so-called conservative justices was not sufficiently reliable on the Second Amendment, again, think Chief Justice John Roberts, FYI, it shouldn't matter, right? The conservatives would still be able to get the 5 votes they need to win the case in favor of Second Amendment fundamental rights, and they would have that with the 5 justices, Clarence Thomas, Sam Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, right? Even if you don't have John Roberts, you in theory would still have those 5 if, again, their views of the Second Amendment continue to be consistent with some of the things they've said in judicial rulings in the past. And my friends, that is why I suspect that the Supreme Court granted certiorari, or agreed to hear, the case we've talked a lot about, the New York State Rifle and Pistol Association versus Bruen case. And I'm guessing that the conservatives on the high court finally thought that they finally have 5 solid votes to fully enforce the Second Amendment as it's written, and thereby expand the constitutional protections currently enforced by the Supreme Court and other federal courts in a robust way, something that hasn't been happening as much as, frankly, it should. So this is probably the best guess about what happened and how we're now in this position with respect to the Second Amendment in the Supreme Court based on all the publicly available evidence. Now, in another video, I talk quite a bit about what I expect at oral argument in the Bruen case. So check out that if you want to hear more information about that case. But for now, let me just say that during oral argument, you probably want to keep your eye on Justice Kavanaugh and on Chief Justice Roberts to kind of see how they're approaching the case, what questions they're asked. These are the 2 justices who are most likely going to be considered the swing votes in the case. And one of them, of course, is going to need to vote with the other so-called conservatives in support of the right to carry firearms in public under the Second Amendment in order for gun owners to win the case the way they want it to win. And of course, in my view, you can just about ignore all of the liberal justices. That's Justice Breyer, Justice Kagan, and Justice Sotomayor. I think that they will never vote in favor of a Second Amendment right. And as a matter of fact, they're just not in play. Again, fortunately, from a matter of math, there are only 3 votes. And again, that's not enough to get to the 5 votes you need to win a case before the Supreme Court. To wrap up, today I gave you a little bit of what I consider an insider's guide about how the Supreme Court works and what has probably been going on there over the last 10 years when it comes to the Second Amendment and Second Amendment jurisprudence. And now you know why I think the Supreme Court probably hasn't heard a huge Second Amendment case in many years. In fact, well over a decade, right? Bottom line, it's a personnel issue about who the justices are and their views of jurisprudence and the law in American life. And it does seem kind of funny to say it's a personnel issue when you're talking about the U.S. Supreme Court, but I think really that is a big part of what it's all about and why these judicial confirmation fights and who the president is and who gets to pick these judges and who gets to confirm these justices are a huge deal to American life and how we order our society. Okay, well, thanks for joining me today at the 4 Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. If you like what you heard, please subscribe to this channel and spread the word. I really appreciate that. And we'll see you next time soon at the 4 Boxes Diner.
Orders up. Table 2A.